welcome to LexTalk World Talk Show presented by Clickaway Creators. Today we have Ms. Bhawna Bakshi with us, a legal advisor based on Singapore office of DFDL. Done her master's in international business law from National University of Singapore and has authority to present several research papers, international conferences. Her practice area is merger and acquisition, banking and finance. She particularly works on some of the most challenging and complex cross-border transactions in Myanmar and also assists a regional matter involving multi-jurisdictional advisors in which DLDF operates and collaborate with local law firms. So now, without further ado, let's dive to know more about her. So hi Bhawna. Thanks for joining us.
Hi, thank you so much for giving me this opportunity. It's like an immense pleasure to be here. Thanks a lot.
Same here, same for us. So our audience wants to know more about your journey, how you have gone through it and everything. So it will be better if you can share it from your own side.
Sure, thank you. So I am an Indian qualified lawyer. I graduated in 2014 and I worked in India for approximately a year. And after that, I went to Singapore for pursuing my Master's of Laws, specializing in international business laws. And thereafter, I joined DFDL in 2017. That was my first job after I completed my Master's. And the opportunity was based out of Myanmar. So Myanmar at that time was a difficult country for an expat to relocate because they had this Rohingya crisis going on. So, but I was like, I wanted to take that opportunity at that time. Obviously, as a fresh graduate, you want to take up challenges no matter where they are. And so, and also there's this benefit of working in Myanmar for an Indian qualified lawyer because most of the laws, the substantive laws and also the procedural laws, they're same like we have in India. So we have the same Indian Penal Code, we have the same Civil Procedure Code. In fact, we have the same Indian Contract Act. So it's easier to understand the legal situation out there, save for a few laws which are recently evolved or have been enforced, the laws are same. So that provides a very good footing, I would say, for an Indian qualified lawyer to work in Myanmar. So considering that, I decided to make the move and I relocated to Myanmar in 2017. So after that, I worked there for approx 2 years, a little more than that, where I was basically advising on the offshore investments in Myanmar and also outside Myanmar. And following that, in 2020, I relocated to Singapore, same like internal relocation to DFDL office in Singapore to take up a regional role where in addition to my team in Myanmar, I also assist my team members based in different countries in Southeast Asia like Vietnam, Thailand, Laos, Philippines, Malaysia, and Cambodia. So it's like in Singapore, we have this ASEAN Desk, which is the main focal point of all the jurisdictions in which DFDL works. And other than that, we also cover Asia as such, where we have our direct presence in Bangladesh. And other than that, we also work with the local law firms in Bhutan, Nepal. So, I mean, that's how our network is quite expanded. And we work across the Asia, I would say, not specifically the Southeast Asia.
Okay.
And so since 2020, since I relocated to Singapore, I have been working remotely. I have to accept that because COVID things strike in and it's almost 2 years. And now at present, I'm working remotely and I'm based out of India. As I came home after the second wave of COVID hit India. So since then, I have been working remotely. Now, since the borders are open, then I'll be getting back to Singapore and juggling between the two countries.
That's amazing. So we also would like to know some examples, like tell us about how complex legal issue you have worked on and describe the complexity if you can, and tell us how you approach it so that, people, young lawyers can really relate to that.
Sure. So I would be able to explain more about the Myanmar because I have my hands-on experience out there. But I would say this is a similar situation which prevails across most of the countries in Southeast Asia. So just to quote a recent example, in the beginning of this year, I was working on a financing transaction It was a very huge transaction, one of the biggest in Southeast Asia, involving a technology-run platform. So what happened there is like, and that is actually a peculiarity of countries, developing countries, I would say, like Myanmar, that the laws are drafted, they have clear wordings, the provisions are quite clear, but there is always an element of vagueness which is involved there or added there, which gives a good discretion to the regulatory authorities. And then what happens in that situation, that there is back and forth and discussions with the regulators, because you need understanding, and you would prefer to have a practical approach of how the laws are being practiced. So that is actually a gap, I would say, between the law and the practice. So what happens at that time is, like, since it was a huge transaction, so there were a lot of security agreements involved. But in Myanmar, there is another restriction that as a foreign company or a foreigner, you cannot hold title over immovable property, be it like the real property, I would say. So that is a restriction. And if you tend to do that, the registration is not possible. And if a security is not registered, then it's void. So it can't be enforced. So that is another concern which needs to be highlighted wherever we have any financing which involves Myanmar. So in this particular transaction, the main issue was, since there were a lot of assets involved, it was very difficult to ascertain the value of the assets. So when we couldn't ascertain the value of the assets, it was impossible to pay the stamp duty. Correct. And when you cannot pay the stamp duty, or you're unable to do that thing, the entire document becomes it cannot be presented as evidence before the courts in Myanmar. It's a similar situation we have in India. So that was a difficult situation, and we were about to finalize the entire financing process, and we couldn't understand, or we could not ascertain the value of the assets being securitized. So just 2 weeks before the finalization of the transaction, we had to change the form of security, and where we decided to change the form of security. Obviously, I'm sorry, for the confidentiality purposes, I would not be able to describe further on what form of security we shifted from. But just like we initially proposed to have charge, but considering the difficulties in terms of payment of stamp duty and also the registration, we decided to change it to hypothecation. So, which relieved us about the payment of stamp duty calculation and everything, because there is this very intrigue thing with hypothecation, like if you have unattested deed of hypothecation, that need not be stamped. And just in practice, some tax authorities, what they do, like they have the standard amount which they impose the stamp duty, like considering that amount. However, under the law, it's not required. So even to like be on the safer side, so in a situation where the tax authorities say that, okay, we have to impose the stamp duty, we were covered up, because that was a standard particular amount that is not more than, I believe, $150. So that they can do. But other than that, because if we sit down and start calculating the value of the assets, it would have been completely impossible to get the document stamped. And in non-payment of stamp duty would make the entire agreement redundant. So it was just at the very last moment that we changed the form of security, when lenders who were all offshore based out of US, they agreed and we finalized. And that's how the entire complexity, which was evolving for a month around the payment of stamp duty and also the registration with the company's registrar, was resolved. So that was a very complex issue and a very wide financing that we handled, and specifically considering the entire Southeast Asia. So we are in DFDL, we had another jurisdiction in addition to Myanmar, which was involved. And we both were, so that was a little, I would say a simpler approach as compared to Myanmar, but Myanmar's situation was a bit complex. And also at the same time, we had, so the transaction was finalized today, and the next day we had this political coup which came in February. So I think we were actually blessed, I would say, that we were able to close the transaction the night before, and the next morning we woke up to the news of political coup, and otherwise it would have been very difficult to complete this financing. So
Oh,
yeah.
very well said, and such a nice example. Maybe people can really relate to this.
Yeah, I mean, that is something I would say is peculiar situation whenever it comes to any developing countries, because it's
Correct,
very difficult to sit in this gap.
definitely. So, like the pandemic really shows some courts were moving towards remote processing and availabilities. Is this situation and a possible way to increase the access to justice? What's your opinion on that?
So, I mean, I may not be in a position to have a clear cut answer that it's yes or no, because what I believe is like certainly virtual courts, or I would say the virtual facilities as such to access justice, are very important, and specifically in a situation where we had this unprecedented crisis of COVID. And actually, this is the virtual courts are not a new concept. They came in way back in 1996, 97. Also, one of the professors, Frederick, they quoted that uh, actually he had a foresight that there could be a possibility when tomorrow there would not be a physical courtroom and things would be turning into a virtual scenario. So, as per his understanding, courtroom is a place where justice, actually it's a place of adjudication where justice is administered, and it doesn't make a difference where it's a physical courtroom or a virtual courtroom. Like I will put another example. We have technology court in Singapore. So, and it was established way back in 1995, when I would say hardly countries would aware of how a virtual court may work. Obviously, things have been evolved. It may not have been the perfect the way it operates now, way back then. But yes, we had this concept then as well. So coming back to the question, that I would not be able to say a yes or a no clearly, because I feel it depends on the infrastructure. Very important thing. And specifically for a developing nation like ours, uh, we still have a good percentage of lawyers, specifically the litigation lawyers, who may even not have access to laptop or even a computer system.
Correct.
So in that case, uh, it would be very difficult to say that yes, it is actually on a progressive front where the access to justice is being very easily given. However, on the other side, when we compare a rural versus urban scenario, in urban areas, I believe almost everyone has access to internet, laptop, or computer system, and it's very easier for them to access the virtual justice provision. So there, yes, it's actually a blessing in disguise. But at the same time, it depends on how we see or how we understand or utilize this opportunity. So this is a situation when we have to actually turn this opportunity as on the path of growth, where we have to learn and also teach people on how to use this, on how to utilize this. So it has both pros and cons attached, but it all depends on what all means of accessing or the infrastructure we are having. And certainly the skills plays a very important part. It's quite important, because even if you have the entire infrastructure in front of you and you don't have the skills on how to use it, it would again be redundant. So it's very important that we learn what is best possible way we can utilize this, use all the resources which are available in front of us, and accordingly utilize it and use it in the path of growth.
Correct. Very well said. And thank you for putting your opinion on it. Of course, yes, you have to get updated with the technology, and then only the path of growth is open for you. So in the same opinion, I would ask you, in this era of legal technology, what is the most commonly used tool for you as a lawyer?
Many, I would say, because I think, like any other lawyer, I have myself been struggling with the very important part, or I would say with expectation of being a multitasker. And that is something I struggle on everyday basis. So I use a lot of tools like the Dropbox, which is the most streamlined access to documents I ever had since I started my career. And then obviously video conferencing tools, very important since we all are having these remote working scenario these days.
Correct.
And then I would say, which is very important for a lawyer, is the recording of the billable hours. Because every hour we put in for the client work is billed to the client. And when we don't have an efficient system, or I would say a proper software for doing that, it's all redundant, because the invoices at the end do not reflect the proper time you are contributing to a particular matter. So that's another thing which is very important. Then there are also other documents automation tools, like and in addition, I do use a lot of tools which help me to convert the PDF versus Word. Like, I have to accept that, and I don't step back from denying it. Okay, I don't do that, because a lot of I come across a lot of agreements where I may be required to add my comments, make changes, and they are not very friendly because those are scanned documents and all. So considering all these things, I do use those tools as well. Then I also use the VoIP, the voice over internet process, the protocol. So yes, there are many. In fact, I would say I keep on researching on everyday basis how things could be developed further, and I can have more tools to ease my burden.
Correct. Oh, very nice. That's nice. Okay, last question from my end would be like, time is money. For in any profession, it is, right? Especially in legal, you have to abide by your time. So how do you ensure to have a proper time management, or I would say, what is your time management mantra?
Yeah, so that is something I have difficulty on everyday basis. So every day comes with a new challenge where I'm in a situation like I really end up pulling my hair out. So so in that case, because there's always an expectation from you that you need to be a multitasker, no matter on what you're working and how you're working. And in addition to that, it's always expected that you need to be efficient in everything. So it doesn't make a difference that how many things you're juggling with at the same time. And specifically, like I would say, for a lawyer like me, and I'm sure there must be many out there who are working with multiple jurisdictions at the same time. Like when I'm working on a regional matter, I am juggling with the transaction, which involves advice, say in Indonesia, Thailand, Philippines, Malaysia. So in addition to the time difference, I am trying to deal with the expectations of the local team out there, considering their position and how busy they are or how equipped they are. At the end of the day, I also have my personal matters and advices on which I am working on, right? So considering all these things, every day is a challenge. But what I do is, like, which is very important for me, I always take notes, and my day starts with a to-do list. So I have two to-do lists running simultaneously. One is specific to my day, and the other is specific to my month, so that I clear the things which are important in a day, because it helps me to prioritize things. And then I have another way, because most of the lawyers, they are very active either early in the morning or late at night. But my brain is most active in the afternoon.
Oh.
So I take all brainstorming matters after, say, 2 p.m. So the time between 2 p.m. and evening, you could say 6, is the most productive time for me. So, and I keep the other things aside, and all my, the brainstorming advices and the complex transactions or matters, they are dedicated to those particular slot. And after that, so the remaining part of the day, I shift my non-billable matters, of course, and other admin work, so that my day is arranged in a way I am able to complete my to-do list for that particular day. Otherwise, obviously, it would be added to my monthly list instead. And I can't dare to add the client work there in the monthly list. So that is something I really take care, and I have to juggle. Otherwise, I may end up missing a lot of deadlines.
That's really nice, and that's really lovely how inspirately you have set a standard for the upcoming lawyers. Prioritize your work, finish with your to-do list, and just try to practice at the best, like whatever suits you, days early in the morning or the afternoon or the night.
That is important. And one more thing I would like to add in here, it's very, very important that you take breaks. No matter it's like 15 minutes break, 10 minutes break, or just a 5 minutes break in between.
Correct.
These are in addition to the breaks you have during your lunchtime or something, because you are focusing on one thing. It's very difficult to just jump onto another immediately.
Correct.
So you need a transition in between. And I focus on that. Otherwise, I'm always juggling in so many things, and I may end up putting one to the other.
That's true. That's really true. So thank you so much for sharing such great insight, and we will further have more chats with you in future, maybe with trending more international legal topics. So for our viewers, if you like our chat with Ms. Bakshi, do like our page, share our video, and subscribe our channel, Clickaway Creators. And we'll be coming up with more legal topics with you. This is Ayushi from LexTalk World.